Good morning. My name is Arkady Frekhtman. I'm a New York City personal injury trial lawyer. And today I wanted to talk about the new Florida law that passed. It's known as tort reform, and it's changing the way personal injury lawsuits are being handled in the state of Florida. It was passed just last week, I believe on March 24th, by a vote of about 23 to 15. So it was pretty close. And then the governor signed it into law. And it makes four major changes. Number one, it lowers the statute of limitations from 4 years all the way down to 2 years. So that basically means that if you're involved in any type of personal injury incident in the state of Florida, such as a car crash, a slip and fall, or anything else with respect to negligence, instead of having 4 years to file a lawsuit, you only have 2 years. And a lot of states have, like for example, in New York, we have 3 years. A lot of states have 2 years. Some states have 4 years. I think 4 is probably the longest. But it's important to give people a longer window because this isn't just the time to file a claim. You could be getting medical care, but you may not know the full extent of your injuries, and you may have even hired an attorney, and the attorney may send a letter to the insurance company with your medical record known as a settlement package. And then you may have started negotiations, but for whatever reason, maybe because you're thinking about doing a surgery, or maybe because you feel like there's an offer on the table and you may be waiting for a larger offer, you may not actually want to file the lawsuit right away. But this kind of limits your time. You have to file it within 2 years or else you're forever precluded. So that's the first change. The second change has to do with what's known as comparative versus contributory negligence. And what that basically means is before the law changed, Florida was a pure comparative state. And comparative negligence means that the jury just looks at the issue of fault. So if you have two parties, the plaintiff who is suing and the defendant, right? Let's say it's a car crash case and the defendant changed lanes, but the plaintiff may have also been, moving laterally, moving sideways, and the two of them collided. So if the jury said, you know what, I believe the defendant is 60% at fault, but I believe the plaintiff is also at fault. The plaintiff is 40% at fault. So what would happen is the plaintiff would be able to recover 60% of their damages. So for example, if they won $1 million, they would get $600,000 because you're not entitled to recover for your percentage of fault. And it doesn't matter, right? Even if the plaintiff was found to be 90% at fault, he could still recover, he or she could still recover for that 10% because it's purely comparative. But the way they changed it now, the new law says that if the plaintiff is more than 50% at fault, then they get nothing. So that's a major change. That's a major change. So for example, if you get into some kind of like that's a good example, changing lanes where both parties could be at fault, and you may think, hey, the defendant was at fault, but then for whatever reason, the jury says, you know what, I think the defendant was at fault 49%, but I feel like you are at fault 51% because you were also moving, or maybe because of the points of impact. Now you're like out of luck, right? What can you do as a plaintiff? You're not going to recover anything. Whereas before, if you were 51% at fault, you could still recover a substantial amount. Like if it's $1 million recovery, you would still get almost $500,000, right? You would get $490,000, but now you would get zero. So that's a major change. And the third change they made is with respect to medical payments. I guess they felt like that they're saying they feel like there's too many lawsuits in Florida, there's too many plaintiffs' attorneys, too many recoveries. I don't know if that's true. I don't practice in Florida. I don't think so. I think this is more like the insurance industry has a strong lobby, and that lobby is really working to help the corporate interests. It's not enough that, during COVID, the insurance industry kind of got like a little bit of a pass because people weren't driving and they had all these reserves, a lot of money in reserves, and they're making billions and billions of dollars, but for whatever reason, they just want more. They're greedy. And so they pass these rules that are just unfair. But this one basically says that in order to get future medical expenses, they have to look at the amount that's actually paid and only the amount that's actually paid. So if you get what are known as collateral sources, which are other sources of paying your medicals, such as, for example, your health insurance or Medicare or Medicaid. All of that gets excluded, and they look at only the amount that's actually paid. It's kind of like okay to do that for the past medicals. Let's say I get into an accident in, 2020, and now it's 2023 and I'm going to trial. For the past, that's fine, right? Because I could say, hey, this was paid by your health insurance, so you don't get that back. This was paid by Medicare, you don't get that back. But this was not paid. This you had to pay out of pocket. So you have to pay this back. That makes sense. But for the future, it's kind of hard to do, because how do you know if a doctor comes into court and says, look, this person has serious medical expenses, they're going to need a fusion surgery, that's $100,000 surgery. How do you know how much of that will be paid by the insurance versus how much of it you'll be responsible for? And so because you don't know that, it's a little bit unfair to base it on the amount actually paid in the future. So we'll have to look into that to see how Florida deals with that. And then the fourth change that they made, the fourth major change, is what's known as letters of protection or liens. Before, you could use a letter of protection, meaning like if you have no other source of payment and you're really injured and you need to get medical care, your lawyer could call a doctor who's willing to participate, and the doctor would sign what's known as a letter of protection with your lawyer. And what that essentially means is the doctor wouldn't get any payment now, and you would get treatment. The doctor would give you medical care. But then at the end of the case, after the case was won, let's say you won $1 million and you're getting $700,000, well, then the doctor would give you his or her bill and say, look, these are, for example, I had 10 physical therapy visits. Each visit was $100. So it's a $1,000 bill, and you have to pay this bill. And all of this would be kept kind of private. But now what they're saying is you have to disclose all of the details of these letters of protections or liens, including disclosing the actual letter, disclosing the terms. And some of these doctors, what they would do is they would sell, because if they would have a lot of these letters of protection, they would then sell them to third parties and do all kinds of transactions. So all of that gets disclosed too. So that's the final change. So let us know what you think. I mean, this is a very controversial topic. In fact, there was an article in a blog, and they talked about one major law firm, a really big law firm, Morgan & Morgan in Florida. Their response to this tort reform law was to say that, fine, this is a shot at the bow, right? This is a shot against us. This is personal. So now we're not going to give any more extensions. It's pretty typical, like when you file a lawsuit, the defendant will call you and say, look, we've been retained by the insurance company to appear and to answer your lawsuit. Can you give us like a 2-week extension? And usually they say, yeah, you could have 2 weeks, you could have 30 days. It's just professional courtesy. And they're so mad about this particular rule and all of these changes. And they say, look, this goes to our livelihood. This goes to our family's livelihood. This goes to our client's livelihood. We're so upset with this that no matter what, we're not giving you any more extensions. It's just going to be, we're going to go to war against you. And they're putting up a fight against the insurance industry. So let us know what you think about that. Let us know what you think about these changes if you're in Florida or if you have a case in Florida. Okay, thank you so much. Please like and subscribe to our channel. Let us know what other topics you want us to discuss, and we are here for you. Have a great day.